What happens when the people meant to uphold justice become the ones standing in its way? When two ordinary citizens, Steele and Trevor Mloud, decide to take on the courtroom alone, the system itself begins to tremble. This isn't just about guilt or innocence. It's about power, control, and the cost of defiance. Stay till the end, because what unfolds will change how you see justice forever. Don't forget to subscribe so you never miss the truth they tried to silence.
Ms. Steele, you understand that you have the right to ask questions of any witnesses brought by the state. The state has the burden of proving the case against you beyond a reasonable doubt. You do not have to give any testimony or evidence against yourself. You have a Fifth Amendment right against self-incrimination, and the state needs to prove the case beyond a reasonable doubt. All right? Do you understand?
The courtroom crossfire. It began as any other hearing: wooden benches, sterile lights, and the uncomfortable rustling of papers, which shook the room. However, it changed the moment Steele entered. She was not a passive defendant who was waiting until she was judged. She was prepared to fight. Symbolizing herself, Sydney was a tall person who was not ready to bow to the robe of authority. Her voice was strong, her questions sharp, and every word which she uttered cut through the sameness of the court procedure. The prosecution did not anticipate such amount of firepower by a person not trained to be a lawyer. Sydney was not merely defending herself, she was defending her right of hearing. The judge attempted to maintain control, interrupting her points, reminding her of the procedure. But Sydney resisted with undiminished strength. She required clarity in the record, challenged discrepancies, and even highlighted indistinct expressions that the majority of defendants would be oblivious. Her assurance was even bordered with boldness, yet the boldness rendered her charismatic. In a different court of law, Trevor Mloud was doing so. He was a composed and yet aggressive person who questioned all his assumptions. The two defendants transformed their hearings into platforms of responsibility. The state served to make people silent rather than to resist, and that resistance was tense and could be felt through the screen. At the conclusion of the interview, it became crystal clear to both Sydney and Trevor that they were not going to be quiet. But what had been lurking in the air was the question: how long would courage resist the cogs and wheels of the machine?
So you said that you were observing me in your rearview mirror when I did all of these. Okay. So if you're observing me in my rearview mirror, how are you able to see how close I'm driving behind another car? If you're looking in your rearview mirror, you would see the car that's in front of me. You wouldn't be able to see my car.
I can see your car and the car in front of you.
Got you. So how are you able to determine how close my tires were to the trunk of the car in front of me?
Anatomy of defiance. Rebellion is not defiance. Defiance is a game of strength and principle. To Sydney Steele, any communication with the court was a juggling act between the need to exercise her rights and to not cross the intangible boundary of contempt. It was not a carefree tone that she used, but was calculated, controlled, and based in frustration with a system where confusion seemed to be the order of the day. All her objections, all her demands to detail, were a reassertion of control over a method which lives on intimidation. The patience of the judge started faltering. Sydney appeared to be drawing imaginary lines in sand with every objection, lines which the court was not accustomed to venerating. The prosecutor, who wanted to show that he is still superior, had started rejecting her points as irrelevant or non-responsive. But every rejection was adding to her determination. It was not merely a battle against a charge, as she was also fighting to be considered a partner in her own defense. Trevor Mloud replicated such disobedience. His court interviews were less boisterous, but as strong nonetheless. His words were moral in nature when he said them. He was questioning motives, procedures, and discrepancies in the evidence. Similar to Sydney, Trevor would not accept the role given to him, which is the frightened defendant. Rather, he turned into the accuser, interlocutor, the conscience of the room. The harder they struggled, the harder the courts opposed. The gavel increased, the interruptions became more acute, and notwithstanding this, they both stood their ground. Rebellion had provided them with an expression, but a very dangerous expression in a place where silence was to be made.
I was monitoring traffic in my rearview mirror. I observed a white SUV changing several lanes, not giving the public enough notice that she was changing lanes, nor was she using a nor was the vehicle using a turn signal. I observed the vehicle getting closer to me as she was changing lanes. She was also following another vehicle too close. Once she changed from lanes 2 back to lane 1 several times, she passed me. From lane 3 to lane 2, she passed me in lane 3, and that's when I conducted a traffic stop on that vehicle.
Construction of a defense without a shield. It is any kind of a tightrope walking without a net to be able to represent yourself in court. Any failure is fatal. Every pause can be taken advantage of. Sydney Steele was aware of it, and fear was not a word in her vocabulary. Her defense was not refined, but emotional. Her filings were not typed, her references faulty, yet all her movements were wholehearted and passionate. She represented the soul of the self-represented. Impossible to make, coarse and gritty. That was the same struggle Trevor Mloud had. His cross-examinations were feeble but sincere. He posed questions that people were scared to do. His policy was less a legalistic policy than a human policy. Common sense and emotional truth were his arrows, often bewildering the prosecution with the demands of an old-fashioned back and forth of drilled law. However, self-representation is empowering and punishing. The language of the courtroom is its own, cold, coded, and elitist. The judges, the prosecutors, even the clerks are fluent in the language, yet the pro se defendants are aliens to their defense. The further Sydney and Trevor talked, the greater was the chance that they would be misinterpreted. Nevertheless, through the legal landmines, the two defendants had their lapses. Sydney revealed the technical loopholes in her case that compelled the prosecutor to take a break. The persistence of Trevor created inconsistencies that a lawyer could not have detected. It was dirty, all right, but effective. Their fearlessness had shown something chilling. At times, there is nothing that fits in within the rules of the system, and that fact, at all events, untold, shakes the fundamentals of power.
Well, I can't let you represent yourself until I establish a couple things or I'm going to be in trouble. Okay? Do you understand that the maximum penalty that you could face for the charges that you're here for is up to 3 years in prison and or $1,000?
I don't understand the nature and cause of the action against me, so I
What is it that you don't understand? Do you not understand how long 3 years is or how much the fine is that I've articulated? Can you tell me what
I
it is
don't
you don't
understand the
understand?
nature and cause of the action against me because there's no established jurisdiction.
That's not what I'm asking you right now.
The procedure power play. The courts do not operate on justice, they operate on procedure. And there is procedure, and procedure, as Sydney Steele had studied, is the most cutting-edge weapon against the untrained. Whenever she attempted to speak out of the heart, the judge stopped her with a chilly reminder. That is not how it works. It was not a trial at all. It was a performance, and Sydney had not been given the script. The prosecution acted with accuracy, referring to rules never heard of by her. Each protest was a kind of trap. All the sustains sounded like the verdict preceding the verdict. Yet in her, there was a fighting spirit that would not give up. Sydney started to read compulsively. She interpreted case law as a survival language. She would rehearse protests before the mirror and had to learn how to find balance between authority and relaxed accuracy. The following time she was in the court, she sounded different, more measured, deliberate, aware. She started referring to precedents, incidents of evidence, compelling the court to apply the same to her. The judge interrupted, yet this time Sydney appealed to the rulebook itself. Trevor Mloud was changing himself. He started talking with the confidence of a man that had studied the battlefield, whereas he was hesitant and uncertain. In cases where the prosecutor incriminated him by giving false information, Trevor contradicted him by providing the precise time of the record. The courtroom had to pause, and in an instant it was not two defendants, it was two forces, regaining power with the help of knowledge. But change of power does not pass unnoticed. The better the language of the system was mastered by Sydney and Trevor, the greater was the opposition. There were more distinct interruptions. Decisions were made quicker and colder. The court might sense the loss of control, and that was the worst discovery of all.
The day this happened, I stopped at the gas station. At the time, I was 6 months pregnant. I stopped at the gas station to grab some water. Get out of the gas station, I turn right. As soon as I turn right, I turn into a light. I pulled behind the police officer. No other car was in front of me other than the police officer. When the light changed, it's like he wasn't moving. So I put my signal on to get in the lane to the right of me. I got in the lane to the right of me. He then got in the lane behind me. And I looked in my rearview mirror and I'm like, he is driving so close to me. Like, he was so close. I could not see his tires. This is why I asked these questions, because in driver's training, they teach you have to at least be able to see the car's tires behind you. So that's how I was able to determine that he was driving too close to me. It was not a car length behind me. So then I'm like, okay. So I put my signal on, get back in the left lane. He gets back in the left lane. So I'm like, what is happening right now? Like, I was so confused as to what's happening. I'm like, am I in his way? What's going on? So then I did get back into the right lane. And when I went to get into the right lane, that's when he turned his light on and pulled me over. And I was confused as to one, why he chose to do that. Because I was, like I said, I was just confused. And he asked me, I asked him, why did you pull me over? And he said, are you in a hurry or something like that? And I was like, well, I'm trying to get to my hair appointment because I was going to get my hair done for my baby shower. And he's like, okay, and then asked for my information. And when he came back and told me, one, driving too close, I'm like, how was I driving too close when I pulled up behind you at a red light? So I literally was not driving. You weren't driving. The light was red.
The courtroom turns against you. At some point in all cases that we represent ourselves, the courtroom ceases to pass off as neutral. In the case of Sydney, this occurred when she approached the judge suspecting that he was biased. The cold came back to the room immediately. What was a proceeding turned out to be confrontational. The voice of the judge became harder. The grin on the face of the prosecutor broadened, and even the stenographer appeared to write more rapidly. Sydney had broken an unspoken rule that you may dispute the facts, not the authority. Trevor lost his head in a different way, but experienced the same. The courtroom broke out when he leveled misrepresentation of evidence against the prosecutor. Objections flew like arrows. The judge was telling him off, and it was in a clipped and formal way. You are walking on thin ice, Mr. Mloud. But Trevor didn't back down. He had already tread fire. A word of caution was useless. What the two found that day was the subliminal hierarchy of justice. Veracity was subordinate to good manners. Fairness only lasted as long as it did not threaten domination. Whenever they talked, they were not only battling their indictments, but they were also battling to have the right to speak. Any complaint they made appeared to be penalized. Motions were denied faster. Any sort of comments were disqualified prior to completion. But they persisted, and this perseverance was in itself a revolt. The more they were smothered, the brighter their voice had been heard out of the walls of that courtroom. And there were cracks appearing in the polished surface of the system first. The composure of the judges failed. There was an uncomfortable movement in the audience. Even the court officials appeared to look dumbfounded, because rebellion mixed with truth sends the power trembling.
If you don't understand it, I'm going to revoke your right to represent yourself and have an attorney represent you because I can't establish that you know what you're doing.
And still, I found you not guilty of the offenses before the court. Each of you are given testimony in this case. Each person has submitted sworn testimony without additional evidence. Neither testimony has greater weight than the other. Therefore, the court is not able to determine beyond a reasonable doubt that you committed an offense in this case and finds you not guilty on both offenses.
The turning point. All the storms come to a calmness. That wavering pause of some prelude to being known. In the case of Sydney Steele, this came during her hearing next. Gone was the madcap defendant who had fallen over procedure. She was in the courtroom, composed, considered, and unaffected. Her documents were named, her references identified. When the prosecution attempted to misrepresent her words, she did not counter it. She went to precedent. Her voice was not emotive, it was incisive. The judge had never been hesitant to make a decision before. The balance of power had changed, however, marginally. This turning point of Trevor Mloud was more silent but no less immense. He started perceiving that the court was not only a locus of law, it was theater, and persuasion was as essential as reality. So he changed his delivery. His tone became softer, his words a song which even those who were doubtful came to listen to. "I am not demanding treatment, sir," he said once with his eyes fixed on the judge. "I'm asking for equal ground." The room fell silent. Empathy was introduced into the equation, the first time. Their stories had become larger than their cases and were intertwined together. They were ceasing to be defendants. They had become icons of rebellion turned to correction. They had been accidentally shaped by the very system which attempted to repress them into powerful supporters. Rarely, however, are turning points happy endings. The more they got strengthened, the more dangerous they became. Courts grew more restrictive about decency, and prosecutors were brutal. Sydney and Trevor had made the system go to the mirror, and it did not like what it was seeing in the reflection.
All right. And still, I found you not guilty of the offenses before the court. Each of you are given testimony in this case. Each person has submitted sworn testimony without additional evidence. Neither testimony has greater weight than the other. Therefore, the court is not able to determine beyond a reasonable doubt that you committed an offense in this case and finds you not guilty on both offenses.
The weight of consequences. Rebelliousness never comes cheap. To Sydney Steele, that was the cost of being alone. The system she criticized started to come together with her. Motions fell into the nothingness of judicial discretion. The scheduling of the hearing changed automatically. Now witnesses who were previously willing to testify just could not remember. It had not happened, but happened. It did not break her, however, but gave her a purpose. Sydney found out that there is no justice in four walls. Justice is on the perseverance of people who are unwilling to be quiet. Trevor Mloud experienced such a cold reprisal. His submissions started disappearing on the docket. The court clerk ceased to make calls back. Any procedural error was applied to doubt his competency. It was a gradually smothering death, not by sentence, but by administration. Yet, even then, he showed up. All hearing, all objections, all closing remarks meant more than it said. It meant more than it said. It meant the man who was not going to be lost in the machinery of the system. Both had an idea of what it was going to be like when the sentencing came. Sydney was spoken at, not prosecuted, a warning to others who should attempt to defend themselves. The conviction of Trevor was seen as unavoidable and his case brushed off as an ill-conceived one. But there is something beneath those determinations that arouses, that doubts. The audience, who had been quiet, were murmuring. The cameras had recorded all the looks, each shudder of the voice of the judge. The more the system penalized them, the more evident it was that it was not defiance that they had committed in the first place, but courage. And manliness, though trampled underfoot, leaves a sound that will never die. The echo of defiance. The gavel dropped, but it did not terminate anything. It was a signal of awakening. The video of the trial in Sydney was shared like a wildfire. It was not a rabble on the run that viewers were watching. It was a citizen who was undertaking a building that appeared to be immovable. Each cut-off utterance, each stifled cry said more than any case. It was what commentators termed as a contemporary day David and Goliath, and never again did the name of Sidney Steele appear on a docket, but rather a reflection of what justice had transformed into. The same thing happened with Trevor. Videos of him silently debunking prosecution arguments, even though every procedural ambush had been thrown at him, spread. His expressions, "I am not fighting the law, I am fighting injustice," rang around forums, podcasts, and community pages. Individuals who had never even seen a courtroom were feeling the pain of his leash. It had attempted to squeeze them into examples, but it made them only more vocal. They were quoted by activists. Their cases were often discussed by legal analysts, and citizens started to pose dangerous questions. What happens when justice is performance? Who is the advocate of the unrepresented? But as their stories were read with inspiration by thousands of people, Sydney and Trevor went through the silent agony of recognizing the price. They had acquired consciousness, but not liberation. Their individual lives shattered under the pressure of undying attention. Friends turned cautious. Opportunities dried up. Nevertheless, they both declined to withdraw. Since the truth had, so to speak, gotten out of the courtroom, and it was not returning with a sorrowful sob. The system strikes back. Rebellion never goes out of mind in institutions. Sydney and Trevor started feeling the invisible pressure squeeze once again, not in courts this time, but in life itself, months after their cases had ended. The renewal of the Sydney license was delayed on the administrative front. Background checks destroyed her job applications. It was obvious, the penalty of defiance is a life sentence without bars. The same happened to Trevor in another form. An interrogation came out of a mere traffic stop. A standard loan application brought about an extended verification. They had gotten out of the courtroom, yet the courtroom had gone after them into the world. It is not merely the act that is being punished in the system, but the daring to act. And still, both would not be written over. Sydney started to train the other people to maneuver the legal maze, to assist defendants in realizing what procedures she used to bumble around in. Trevor began to make videos, cut up his case, and demonstrate to people how power resides right in front of our eyes. Their silence against them developed into learning. They had ceased to fight on their own behalf. They were making armor on behalf of others. Never does power yield without a struggle. Anonymous letters started to be received. Veiled threats, strange calls, online slanders, everything that must be done to remind them of their position. Nevertheless, they both continued talking, aware that each word involved a danger, and each silence involved a larger one. Redemption through resistance. There comes a moment when purpose outlasts pain. For Sydney Steele and Trevor Mloud, that moment came quietly. No headlines, just resolve. Their victory wasn't in verdicts, but in courage that never sleeps again. Sydney turned defiance into advocacy, guiding others through the maze she once feared. Trevor turned reflection into reform, reminding people that justice must be protected from those who twist it. Redemption, they learned, isn't granted, it's reclaimed. Through the cracks in the system, light began to shine. Sydney Steele and Trevor Mloud are the defendants who turned into something much larger, the icons of rebellion, bravery, and sheer reality in a hierarchy-based system. Their voices that were initially rejected reverberated long after the courtroom and made the world challenge the principles of fairness. They did not necessarily win all the legal fights, but they won something greater: awareness, change, and the strength to speak when it is safer to remain quiet. And that is what justice really is, not a sentence, but a statement. It is time to remind us that the power is just as invincible as long as people do not ask questions. Sydney and Trevor did not just defend themselves, they defended a lot of us. Subscribe now because you believe in stories that open the doors to the truth and hold people accountable. It is the start of an era of actual justice.